Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights and business bankruptcy attorney Kirk B. Berkeley discusses making demands.
Today we're going to be talking about making demands. We get a lot of calls from clients where an account debtor has failed to pay on an invoice. The client has probably made a couple collection calls, maybe sent a couple letters, and then they come to the attorneys and they want to elevate the situation a little bit. One of the first things that we always hear is, if you can just send a quick letter from you, the attorney, I know that they'll pay. They just need to hear that we have an attorney involved. And while that might be the case sometimes, most often that's not all that it takes. Usually, if you've had a customer that has ignored your collection calls, there's something else going on. Maybe there's a dispute. Maybe they simply don't have the money. And certainly the added element of a new letter coming from an attorney is helpful and shows that the case has been elevated to the level of an attorney, but it's not the magic bullet in of itself. And we believe that there's an art in even the manner that you make your demand. And so whenever we send a demand letter out from our law firm, we usually abide by a few general principles. One, we want to let them know very clearly that in fact we have been engaged. So we want to start out the demand letter by making sure that it's very clear that that account debtor knows that our client has engaged our firm to collect that debt. That does several things. One, it lets them know very clearly again that it has been elevated to the status of being pursued by an attorney, but also lets that account debtor know that they should be communicating with us, that they should be responding to us. If they have counsel involved, that counsel should be responding to us, that we are now representing our client in collecting this debt. Some of the other things that we like to do are point to and attach the relevant documents that establish the debt. I think it's always a mistake whenever I see a demand letter from an attorney that goes out to somebody that hasn't paid that just says, "You owe us money, please pay." It's important to let the account debtor know exactly what the operative documents are. Maybe it's an invoice. Maybe it's a credit application that has the terms that govern. Maybe it's a contract. But whatever it is, including a loan document, should always be referenced in the demand letter and point to, as much as you can, reference the sections and the terms and conditions that govern the relationship. If the documents are not too voluminous, I recommend attaching them to the demand letter. You start to run into some problems maybe if you have documents that it's just simply not practical to attach them all or send them all in the demand letter. In that situation, you would certainly want to reference the documents. For example, you might say, "Dear account debtor, this letter is in reference to loan document dated whatever date. Please see section 4 of the default provisions that talk about what happens upon a default." So if the documents are too voluminous to attach, you should certainly still reference them. We also then like to make sure that we tell them what the debt is on that date. What exactly is the debt that's owing as of the date of the letter? So as of today, January 1st, 2014, the debt you owe my client is $850,000. You should also then very clearly spell out if in fact there are other interest, penalties, attorney's fees, anything else that might be due and owing, and break that out the best that you can. For example, if you have interest that is accruing, you should point out and be very clear on what the per diem is, so that that account debtor knows that every day that goes on, the debt that was referenced is in fact increasing. They should also know that attorney's fees are going to be included in the debt if you are allowed to collect attorney's fees, what penalties are being incurred. You don't want any surprises. You should also then let the account debtor know where they are to send payment. You don't want any confusion. Is it to be sent to some processing center? Is it now to be sent to the attorney? And you want to keep the letter as short as possible. I recommend demand letters should be no more than 3 pages and try and keep them shorter than that if possible. The more clear and concise you can be, the better, and you'll increase your ability to collect.
This has been another installment of the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.